Contracts 1. General principles. Capacity of parties or competence of parties. Section 11 and 12 of Indian Contract Act 1872. Dear student friends, today I wish to take up capacity of parties or competence of parties revised lecture from Contracts 1 General Principles. This is my 194th lecture in English medium. This lecture was uploaded in Telugu media a few days back. This is a revised lecture. This lecture I uploaded in English long back. This lecture will be an improvement over the previous lecture for your information. In this lecture, we have to discuss about the capacity of parties or competence of parties. This section 10 of Indian Contract Act enunciates that the parties to two competent parties freely consented to enter into a contract. These points I told you in previous classes. So the parties who want to enter into a contract must be legally competent. If they are competent to enter into contract, then only the contract can be valid. If the parties to contract are not competent by virtue of disability by age, by virtue of disability by mental condition, by virtue of disability by law, if any person is declared not competent by virtue of age, any person declared not competent by virtue of mental condition, that is mental disability, or any person declared not qualified by law of the land to enter into contract, they should not enter into contract. In other words, any person who is a major, not minor, any person who is of sound mind, not unsound mind, or any person who is not disqualified by law to enter into contract, disqualified by law, such person is competent to enter into contract. Section 11 and 12 of Indian Contract Act enunciate that Section 11 tells you who are competent. Section 12 tells you how they are not competent, when they are competent, when they are not competent. The detailed information is explained in Section 12. According to Section 11 of the Indian Contract Act, any person who is a minor, who is a major, not minor, who is of sound mind, not unsound mind, who is not declared disqualified, who is declared disqualified by law, is competent to contract. In order to enter into a contract, a person must fulfill three conditions. Firstly, he must be a major by age. Secondly, he must be of sound mind. Thirdly, he must not be disqualified by law in force. So these are the three conditions. If major, sound-minded, not disqualified by law, such person alone can enter into contract. If any one of the conditions is absent, that person is not qualified to enter into contract. So what is this situation? We have to discuss in detail. In first point, section section 11 and 12 deal with capacity of parties or competence of parties to enter into contract. Section 11 of the Indian Contract Act tells that every person who is not a minor, that is major, as per law, and any person who is not of unsound mind, that is sound mind, and who is and any person who is not disqualified by law to which he is subjected to. Such person such person is competent to contract. So, who wants to enter into a contract either from this side or from that side? Firstly, he must be a major, he must be of sound mind, he must be of a person not disqualified by law. That is what Section 11 of the Indian Contract Act tells you. The definition contains these points. So he must be major, sound mind, not disqualified by law to which he is subject to. This is the definition. Now, Section 11 explains in detail about minor contract. What are the instances or circumstances of minor contract? There are 7 instances or circumstances of minor contract we have to discuss. And secondly, in sound mind, Section 12 of Indian Contract Act explains in detail about who is an unsound person. Who is with reference to this, we discuss under 3 situations. One is lunatic, idiot, and intoxicated person. 3 persons. In the third situation, disqualified person, disqualified by law, we discuss about alien enemy, insolvent, and convicted persons. These in minor we discuss 7 situations. In unsoundness we discuss 3 situations. In legal disqualification 3 situations. So if in simple words, person to be qualified or competent to enter into contract, he must be competent by virtue of age, he must be competent by virtue of soundness of mind. Thirdly, he must be competent by virtue of law. So, either he is disqualified, he has legal, whether he has disability by age, not qualified to contract, he has disability, he has mental disability, he is not qualified to contract. If he has legal disability to which he is subjected to, he is not entering into contract. Now, first situation, minor contract. Minor is otherwise known as infant. Minor is otherwise known as infant. Now, first we discuss about minor's contract. In this chapter, minor's contract is most important. This may be asked as short question and also main question. So, minor, a contract entered into with minor, discuss, question may be asked. What is the rule laid down in Mohri Bibi West Dharmadas Ghosh? It may be asked. Depending upon the question, you have to give your answer. These things I will explain in detail in last lecture after remedies. Now, let us now discuss about the 3 aspects. One is minor, 7 situations. Second one is unsound mind, 3 situations. Third one is legally disqualified, 3 situations. All these aspects we have to discuss in this particular lecture. Number 1 is minor or infant. Minor, infancy. Below 7 years is infant, exempted from criminal liability. 8 to 12 years made liable subject to proof of mens rea. These we studied in criminal law. So now coming to the infant or minor. Who is a minor? In India, according to Section 3 of the Indian Majority Act 1875, any person who has not completed the age of 18 years is a minor. If he has completed the age of 18 years completed and above 18 years, he is a major. According to Guardians and Wards Act 1890, Section 4, if any person is appointed as guardian, either legal guardian or testamentary guardian or natural guardian or legal guardian or testamentary guardian, is appointed to look after the person and property of the minor, of the child, the age of minority will be extended to 21 years. So, for minor, sometimes guardians may be appointed to look after for his personal security and property security. In a father may be a father or mother is natural guardian, they may be appointed. You may doubt that when father and mother are there, why should father or mother should be treated as a guardian? Sometimes what happens is father mother don't have any property, grandfather will have property. So when it is an ancestral property, father or mother do not have any right to dispose of the property or alienate property. The grandfather or grandparent may execute a will, all the property in the favor of grandson or grandchild. Then the all property rights are vested with the grandson or granddaughter. Parents do not have. In such situation, even a father or mother may be appointed as guardian. If the father or mother do not like to act and they are unsound mind or otherwise disqualified by conversion or renunciation and renunciation or join renouncing word or any other incompetencies, they may execute a will. They may execute a will and appoint when they were in sound mind. There some by mother or father, natural guardian may execute a will and appoint somebody as guardian. See, in the absence of all these things, sometimes court may appoint some reliable person as guardian. So the guardian may be natural guardian, father or mother, or testamentary guardian appointed by will executed by natural guardian, that is father or mother, or sometimes the court may appoint a guardian. When any guardian is appointed under the Guardians and Wards Act Section 4, the age of minority will be extended to 21 years. So even though he is in completed 20 years, running 21, that boy or girl is a minor, not competent to enter into contract. Only they can enter into contract through the next friend, that is guardian. This is about minor meaning. So any contract entered into with minor is void. Void means invalid in the very beginning. That means no contract exists at all. No contract has been entered into. There is no contract at all. That is why when one contract is not created, no rights and obligations will be created. The first point is a contract entered into with minor is void ab initio. Suppose whether any person knowingly or unknowingly unknowingly the age of a person enters into contract and subsequently the minor tries to avoid the contract, that other person cannot have any remedy in court of law. The most relevant case on this point is Mohri Bibi versus Dharmadas Ghosh. Mohri Bibi versus Dharmadas Ghosh. Mohri Bibi is the guardian of the minor child. Dharmadas Ghosh is the legal representative by virtue of power of attorney, and all these details not necessary. In this case, a minor mortgaged his house or land for 20,000 rupees to a money lender. The money lender gave an advance of 8,000 rupees to the minor. This minor enjoyed that 8,000 rupees and did not execute the contract of mortgage. Then the money lender demanded either you complete the contract by accepting 12,000 rupees remaining or you return my 8,000 rupees. So neither he returns 8,000 rupees nor execute the contract of mortgage by accepting 12,000 rupees. Then the money lender's legal executor brought an action against the when the matter is in dispute, this minor's mother, Mohri Bibi, brought an action against the money lender to set aside the contract contending that a contract with minor is not actionable or maintainable or enforceable. This view of minor's mother was admitted by the lower court and then accepted by the Court of Appeal, and ultimately it went to the Privy Council. In those days, Privy Council was the highest court of judicature. It was the apex court. It was hearing appeals from high courts of Madras, Bombay, and Calcutta in Indian territories. In those days, we did not have any apex court or Supreme Court of India. So this Privy Council laid down that whatever may be the reason, whatever may be the circumstances, knowingly or unknowingly, whoever enters into a contract with minor, that contract is void. The contract is void ab initio means from the very beginning, when once there is no contract at all, there is no question of creation of rights and liabilities, and the case was dismissed. This case was popularly known as the rule in Mohri Bibi versus Dharmadas Ghosh. That is why the question may be asked, what is capacity of contract? Then you have to explain more in about this and other points. You write C 2-3 lines. But in other points also sometimes may be asked as short notes. This question may be asked as short notes or main question depending upon the number of marks allotted to that particular question. You have to answer these tips. I will let you know at the end of the subject, that is in last lecture. So there are 7 situations under minor contract. So the second point is a contract entered into with minor is void ab initio. It is invalid from the very beginning. Second one is contract. A minor can be a promisee but cannot be a promisor. When a contract is entered into with minor, he is entitled to all benefits. He is entitled to all benefits, and he is not answerable. He is not accountable to any losses. Suppose minor is taken as a partner. If a firm gets profit, he will get the share in the profit. If the firm gets losses, he is not answerable for the losses. Simply, if you play with minor playing cards, if he wins the game, the others have to give him money. If others win the case, the minor need not pay money. That is, a minor can be a promisor, a minor can be a promisee or beneficiary. He cannot be a promisor. So in this case, Raghavachari versus Srinivas 1917 case, in this case what happened was, in the Mohri Bibi case, reverse facts. In this case, beneficiary is minor. A minor can sue for the benefit on behalf of sue others through the next friend. So the guardian of the minor can sue outside other party to get the benefit of the minor. So if the minor has to pay any benefit to others, he is not accountable. As in Mohri Bibi case, in Raghavachari case, if he is entitled to get any benefit under the contract, he can file a case against the other party and take the benefit. This is the reverse. This is a minor can be a promisee but cannot be a promisor. So minor enjoys profits and benefits. Minor is not answerable to losses. Second point. Third point, no ratification. No ratification. The wording ratification means subsequent acceptance, subsequent approval. Suppose I am principal. I purchased some books worth 1 lakh as per Bar Council direction without sanction from the management. So management approves the bill for 1 lakh. So that is called the act subsequent approval acceptance of management is called ratification. If management does not ratify, who asked you to purchase the books worth 1 lakh, and if the management did not accept, there is no ratification. there is no rest. Subsequent acceptance are, suppose I may appoint some temporary staff, the management subsequently accept it. Subsequent acceptance or approval is called ratification. So here, when the contract minor entered into a contract, when he is a minor, at the time of minor, subsequently the contract continues for so many years. But so many years, and he became a major, he need not ratify that. For example, a minor entered into a contract at the time of minor, during the age of minority, he is continuous as a partner in that particular partner firm. After some time, he will become a major. When the firm dissolves, he need not. The losses will be shared by other partners, but he does not share the losses, but he will take his capital. He will take his capital back. Other partners will lose it. So that is why even the partner, even after retaining majority, the time of beginning of the contract he was a minor. At the conclusion of the contract he became major. He need not ratify for the obligations or losses when he was in at the age of minor. This is what is called ratification. Ratification. The third point is over. Fourth point, restitution. Restitution. Restitution means a minor may misrepresently entered into a contract and got benefit. He need not reinstate or restore under voidable contract. Suppose restitution means to restitute means to reinstate, to give back. Suppose a house is insured against, then the insurance company will pay 50 lakhs worth of cash or reconstruct the building. Instead of paying 50 lakhs, if the building is reconstructed, it will come to 30 lakhs. Then the insurance company will enjoy the privilege of doctrine of reinstatement. So reinstate or restitute means to give back the property, to restore the property, to keep back the property as it is. That is called restitution or restore. Then when the minor enters into a void contract or voidable contract, knowingly or unknowingly, but there is no obligation on the part of the minor to ratify that contract. So he cannot make the voidable contract. If he ratifies, it becomes valid contract. If he doesn't ratify, it becomes a void contract. That is why a minor doesn't have any obligation to ratify. If he ratifies, that contract becomes valid. He will be liable to make payment. So if he doesn't ratify, that contract will remain as void. He doesn't have any obligation. This is what is called restitution. Restitution. This is he need not restitute. He need not restitute. Previous one is ratification. Now, fifth point is no estoppel. Estoppel is most important topic. Section 15 of the Indian Evidence Act 1872 lays down various provisions relating to estoppel. This topic, estoppel, is very important. It appears in almost all subjects. Not only this chapter, capacity of parties, is very, very important chapter because it appears in most of the subjects. It appears in contracts, it appears in law of torts, it appears in IPC, it appears in Transfer of Property Act, Company Law, so many partnership law, negotiable instrument, so many subjects. The capacity of parties will be appeared, minor contracts will be appeared. So that is why, dear student, you read this chapter as a top priority. Question will come as a main question or short question. Estoppel means I explained in detail about the principle or doctrine of estoppel. It is the principle of natural justice or principle of equity. The word estop means shut the mouth. Shut the mouth. partner by estoppel, agent by estoppel, I explained in detail in contracts 1 and contracts 2 earlier in all the lectures. And anyway, I repeat once again, estop means, the word estoppel is a principle of natural justice. The word estop means shut the mouth. Suppose a person keeps quiet while making a statement with reference to his duty or obligation, and does not prevent that other person to make such statement. In the event the obligation arises, he must meet that obligation without saying anything. For example, I am one of the partners of one of the 5 partners of a partnership firm. One person wants to invest some 5 lakhs in our partnership firm. He is in oscillation whether to deposit 5 lakhs in this firm or not. Naturally, when we want to deposit money in private bank, we think and act. If it is government aided bank, though rate of interest is less, we will deposit in state bank and other nationalized bank. We are not that much daringly deposit a huge amount in private banks. Suppose, for example, one person wants to invest some 5 lakhs in our partnership firm. He is thinking. Then I said, at the time to our firm, the local businessman, a very rich man, visited our partnership firm. Why you are thinking very seriously to invest 5 lakh rupees, sir? You look at that gentleman, Mr. So and so. He is the richest person, highly reputed person in this town. He is our partner. I said. Then that rich man kept quiet. He should have said, why, what you are telling? How can you say that I am your partner? I am not your partner. He should say. But he did not say, and he allowed me to speak that he is our partner, he invested this and that, I am speaking more. He was silent. So, that customer who was doubtful to invest or not, invested that 5 lakhs. Subsequently, the partnership became bankrupt, dissolved. Then the outsider, that is the creditor, can file a case against one partner or all the partners, because the liability of partners is joint and several. If one partner is sued, case is filed against one partner, that one partner alone should repay the amount. If all partners are sued, all of them proportionately pay. Then that outsider who invested 5 lakhs, ignoring all 5 partners, and filed a case against partner by estoppel. Then the partner by estoppel says, why you filed a case against me? I am no way concerned to that partnership. When Mr. Rao said that, I kept quiet out of my friendship or relationship. So I thought that it doesn't look nice to look nice to condemn his statement. I could, no, sir. When you kept quiet, now you keep quiet and pay money. Now you are a partner by estoppel. Similarly, agent by estoppel is there. So many issues are there. This estoppel topic in detail you will study in Indian Evidence Act. There is an independent chapter, section 115 of Indian Evidence Act 1872 deals with this principle of estoppel. So minor by estoppel is over. Sixth point is this view was laid down in Nawab Sadiq Ali Khan versus B.B. Jai Kishori. So in this case, the court held that a minor might have entered into a contract telling that he misrepresented himself as major. A minor, his age is 18, but he said that he was 25 and got the contract entered into, but subsequently he cannot be stopped from enjoying the age of minority. This was the decision given in this case, that is minor by estoppel. Second one is no specific performance. No specific performance. What do you mean by specific performance? A minor should not be asked to do specific performance. Specific performance means whatever is the contract, whatever is for what purpose the contract is entered into, that purpose must be served, completed. That is the reason. For example, A and B enter into a contract. A is a seller, B is a purchaser. The house is 50 lakhs. A sells the house. A wants to sell the house for 50 lakhs. B wants to purchase the house for 50 lakhs. The contract is entered. Some advance is paid. The sale is to be executed within 1 month or 3 months as per the agreement. Meanwhile, house rates increased. The 50 lakh house became 75 lakh. Then seller wants to avoid the contract, telling that I will return your money. Then buyer can file a case against seller for specific performance. No, I don't want return of advance of 5 lakhs. I will give you remaining 45 lakhs. You give me house. That is this thing. Sometimes buyer may avoid the contract. The rates have come down. Suppose the rates, site rates go up and go down. For example, when capital comes to, when it is heard that capital comes to Visakhapatnam, the rates, executive capital comes, the land rates go up. Then when the capital will get shifted from Amravati to Visakhapatnam, the site rates in Amravati come down, like that. So in that case, sometimes the buyer may try to repudiate the contract, seller may try to repudiate the contract. When one party attempts to breach the contract, the other party can bring an action for specific performance. The type of specific performance cannot be asked to minor because the minor cannot be sued to his next friend cannot be sued for specific performance. Next one is vicarious liability. Vicarious liability means one person commits wrong, other person is put to liability. So his next friend, parent or guardian, a natural guardian, parent or testamentary guardian or legal guardian is not liable for acts committed vicariously. That next friend, parent or guardian is not liable for the liability of the minor. So normally a minor is not liable for any liability, but he is liable in one instant, that is section 68 of Indian Contract Act as per principles of natural liability. So minor is not liable for any in any contract, but if the contract is for the basic needs, necessities like food, clothing, shelter, medical expenses, marriage expenses, funeral expenses of parents or another other thing. So whatever items are considered within the meaning of necessities, for in such cases the minor is liable. If the next friend is sued, he will have to meet the liability. So minor normally is not liable for the supply of necessities. Minor is liable. The section 68 of Indian Contract Act speaks about minor's liability. In quasi contract, I will tell you 5 situations of quasi contractual obligation. With this, minor part is over. The second area is unsoundness of mind, insane person. According to the minor matter refers to section 11. According to section 12 of Indian Contract Act, unsound persons and legally not qualified person, legally disqualified persons are not competent to enter into contract. Coming to the second main heading, insane person or unsound person. In section 84 of Indian Penal Code, an insane person is exempted from criminal liability also. A mental man commits murder, exempted from criminal liability. Like this. So, insane means a person of unsound mind. So, there are some persons, though they are majors, they have due to instability of mind, mental imbalance, they are not in a position to decide what is wrong. Mental people they are those who suffer from some disease of the mind. They are not able to know what is right, what is wrong, what is right, what is wrong. Yeah, what is right, what is wrong. Suppose they take the child, run away, and throw the child from building top floor to ground. But they don't know. If the child is thrown out, the child will die. They don't know. So that is why they remove the clothes and go out of the ready to walk in streets without clothes, because they don't know walking without clothes in a public place is indecent. So that is why, because they are mental, they are unsound people. So this unsound sometimes when the person is in sound mind, they enters into contract. That contract is valid. Subsequently, that person became unsound. That contract will be enforceable. When the contract is entered into at the time of unsoundness, subsequently the person became sound, then it can be, the contract can be avoided or repudiated. It is voidable. If the unsound person, if he entered into contract in unsoundness of mind, which he doesn't remember, when he became sound, if he feels genuine, correct, to enforce the contract, he can enforce. That is voidable contract. After reaching soundness, if he can validate the contract, he can validate it, or he can plead the defense of unsoundness, then it will become void contract. So, sometimes a person may be sound mind, sometimes a person may be unsound mind. There are so many cases. Sometimes a person is in normal condition. When BP goes up, when BP becomes angry, and whatever they are doing, they don't know. There are so many matrimonial cases on this point. Matrimonial cases leading to divorce also. If you refer the matrimonial cases, you come across that situation. So long as the wife is in normal condition, moves quickly, due to when she is hurt mentally, then she gets BP and will become imbalanced, gets out of control. She will be mentally in disorder and will do whatever he is doing. She doesn't know whatever. An unsound person is a person suffering from mental disease or mental imbalance, who is not able to know what is right, what is wrong, who is not able to understand the nature and extent of the consequences of the act he or she is doing. So, if contract is entered into such person, is is void under section 12. However, these insane persons or unsound persons are of three categories. One is lunatic, second one is idiot, third one is intoxicated. Lunatic is a person who, a child below the age of 3 years doesn't know what is what. So, this person behaves as if he doesn't have the maturity of a child below the age of 3 years. That person is called lunatic. Secondly, idiot. Idiot means he may be 20 years or 30 years, 40 years, whatever it may be. When somebody he doesn't know, somebody in the family died, he laughs. All are in grief, unbounded grief. They are weeping, crying. But this man is singing songs, dancing. Because he doesn't know. Somebody, some family member died. All the members of the family are unbounded, are in unbounded grief. There he doesn't know what is sorrow, what is joy, what is enjoy, what is good, what is bad. So in one movie, that hero, the old woman dies. Then he was, I am feeling hungry. Give me food. He is asking. So such person may be called idiot. Called idiot. Third one is intoxicated person. Any person due to excessive alcoholism or excessive consumption of alcoholic drinks, wine, excessive consumption of alcoholic drink or consumption of drugs becomes out of mind. So we see when we in a bar, two three persons come to bar very decently. They start speaking. When they place order, the bearer is giving bottles one by one, and after some time, having consumed voluminous liquor, more volume of liquor, their way of talking is different. They are speaking some nonsense because they speak very decently, very politely before consumption of alcoholic drink. Having consumed excessive alcohol, but one's capacity is a quarter bottle. If consumes up to one full bottle, then what he is doing he won't be able to tell. So in such case, whatever he does is no. So this intoxicated person, intoxication section 85 and 86 of Indian Contract Act deal with intoxication as a defense. So voluntary intoxication is not defense. Involuntary intoxication is defense. Suppose that is in criminal law I am telling. Suppose one person takes wine and go to somebody and kill him, he is not exempted from criminal liability. Somebody without his knowledge administered drug, but pouring some intoxicated substance in cool drink and got him intoxicated. In that process, he commits any crime. He may plead the defense. Suppose a man consumes intoxicated substance knowingly, commits wrong, no exemption from liability if without his knowledge intoxicated substance is administered, then defense is available. So intoxicated man is voluntary intoxication and involuntary intoxication persons come with the meaning of insane or unsound persons. So those persons, such persons who are intoxicated, whose mind is of imbalancing condition, mental disability, they are not competent to enter into contract. Now you are in drunk, not now. Let us enter into contract tomorrow. Like that, we will tell them and send him. We don't, no, I will do the contract now itself. Not 50 lakhs, 2.5 crores I am ready to give, he will say, out of drunkenness. But the seller will not agree. No, not now. Today you are ready to pay out of intoxicated affect, influence of intoxication. You are ready to purchase 50 lakh house to 2.5 crores today. You sign. Tomorrow you will say, I don't like it for 50 lakhs and you will demand for 25 lakhs. No, I cannot quarrel with you. And this. So this is what is called insane person. Last one is legally disqualified person. The law of the land declare certain classes of persons are disqualified to enter into contract. They are not competent to enter into contract. Such type of persons are one, alien enemy, insolvent or convict. Alien enemy means when two countries are there, country A, country B, but there are good international relations between these two countries, the subjects of A country can enter into contract with the subjects of B. So the citizen of country A can enter into contract with citizen of B. And during peace time, suppose war broke out between these three countries, the citizen of A will become the enemy of citizen of B. The B becomes the enemy of A. They are called alien enemies. Alien enemies. For example, the war between Russia and Ukraine. Russia and Ukraine war. So the citizens of Ukraine and citizens of Russia are alien enemies. No contract can be entered into between Russian and Ukraine national. So that is there is no contract. Peacetime contracts between two foreign nationals can be entered into. When the war broke out between two countries, one foreign national will become the alien enemy of other national, and vice versa. So that is alien enemy. Second one is insolvent or bankrupt. In India, we call insolvent. In England, we call bankrupt. Insolvent is a person, a sole trader, a single businessman, or partnership business becomes gets dissolved. A sole trading concern or partnerships or firm is running at heavy losses due to excess of liabilities over assets. So assets are 50 crores, liabilities are more than 100 crores. If the business is continued for some more time, the liabilities will be increasing. Suppose 100 liabilities will become 125 crore or 150 crore. So in this case, the person, the partnership firm partners or sole trader, what he thinks is, I have only 50 crore worth assets. The liabilities are creditors are 100 crore. But if I give to one party, other person will beat me. I cannot. The strong creditor will take more money. Innocent creditor will take less money. In order to escape from this liability risk, he will file a petition in district court, that is praying the God to adjudge him as an insolvent. So he files petition, IP petition, insolvency petition in district court. The district court, going through the contents of the contents in insolvency petition, and this insolvent is ready to, the insolvent sole trader or partnership firm is ready to surrender all the assets. All the assets. When IP petition is filed, the owner, if the single businessman, he will surrender all the assets to the court. If it is a partnership, all the assets of the partnership will be surrendered or handed over to the court. Then the court will take over all the assets and will hand over those, entrust those assets to an official called official receiver. That official receiver will dispose of all the properties and distribute the sale proceeds to various creditors on priority as per rules. Fully secured creditors, partly secured creditors, preferential creditors, bills exchange, all these things commerce students are expected to know. There are insolvency accounts. Similar accounts are made. Liquidation chapter in accounts, commerce students study this aspect. Anyway, that is an insolvent who has handed over all the assets to the sole trader or partnership to come to court. Though he is owner, he has a title, he is not qualified to enter into contract because they are handed over to the official receiver. So legally disqualified person, that is insolvent, cannot enter into contract. Last point is convicted person. If a person convicted for any crime, suppose if criminal charges are proved, he is convicted. If criminal charges are not proved, he is acquitted. Suppose a person is alleged to have committed an offence, it may be theft, robbery, kidnapping, abduction, whatever it may be, murder, whatever it may be. When the allegations are in pending, he is called accused. He is accused of murder, he is accused of committing kidnapping, abduction, like that. Though when the matter is decided by court, it is proved that he committed that crime, he committed that murder, rape or kidnapping, he is convicted. He is called convict. That person is called convict. So in this process, when the criminal proceedings are going on as per CRPC provision, criminal procedural process, the person may escape from absconded. That person may be absconded. So in order to arrest a person, the first weapon used by the court is summon. Second weapon used is arrest. If the person is not available, okay, that person cannot be brought to court by summon or arrest warrant, then the next weapon is proclamation, publication of his name. This man is absconding. If anybody is there, catch him and bring him to court. He may be given some reward. That is proclamation. Even then, the proclamation is not worked out. The last resort is attachment of his property. The person, the convicted person, the convict, who is absconded, what are his properties? Wherever his properties are located, those properties are seized by the court. When the properties are seized by the court, though he is the owner, he has a title, he cannot dispose of the property. He cannot enter into a contract. He is disqualified from entering into contract. So that is why a convict also is not qualified to enter into contract. With this, section 11 and 12 with reference to capacity or competence of parties. Minor 7 situations, unsound 3 situations, and legally disqualified 3 situations have been completed. Thank you very much for your patient hearing. Many students are asking many things, dear student. I have strong inclination to deliver lecture on each and every subject. You need not ask anything, but one by one I will do. There are nearly 10,000 subscribers, but very few are not taking interest. I sincerely tell you, don't think that it is self-boasting. This is very, very good opportunity. One man teaching all subjects, but I agree that 1 hour lecture is mental harassment, but it is inevitable and incompatible. If you go to competitive examination center, paying a lot of fee, you are forced to attend classes many hours a day. You are forced to read many books. So the persons aspiring for competitive exams work many hours a day. So if you say that I am ready to pay 5 lakhs of fee, but reduce 1 hour period to 20 minutes, 10 minutes, you request in college, they don't know. The teachers who are working in prestigious institutions deliver classes 1 hour and above. They are uploading lectures in 10 to 20 minutes because they understand the patient hearing of the student they are doing. So because I am not able to do like that, because it is inevitable. If you follow my lectures, you can acquire very good knowledge. Some students are asking whether this bar exam, this is sufficient, or that is, they are asking so many questions. In question and answers topic, I will explain so many things in detail. I will give lectures one by one. So for the last, after completion of last lecture in Telugu media, next day I got cold, cough and this fever. Today I have been recovered. Still cold is not cleared, but since there is long gap, I have given this lecture. I am very inspiring and enthusiastic to deliver more lectures on all the subjects. There is no problem. Make use of the lectures already uploaded, and so that you can get very good knowledge. If you listen to my lectures in a earphone, your language will be improved. That is for those who do not have good vocabulary in English. Thank you very much for your patience.